Judgment in the matter of Micula and others versus Romania.
Lord Lloyd-Jones will explain the decision of the Court.
In December 2013, an international arbitral tribunal made a final investment award in favour of the claimants against Romania. The award related to investments made by the claimants in a large, highly integrated food production operation in Romania prior to Romania's accession to the European Union on the 1st of January 2007. The present appeal is the latest chapter in the claimant's extensive attempts in a number of different jurisdictions to enforce the award against Romania and the attempts of the European Commission to prevent enforcement on the ground that it would infringe EU law prohibiting unlawful state aid. When Romania was negotiating its accession to the European Union, it was told by the EU that an investment incentive scheme for certain regions, known as EGO 24, was contrary to EU state aid rules. As a result, Romania repealed all but one of the incentives under EGO 24. The claimants, who had made their investment on the basis of EGO 24, filed a claim for arbitration under the Convention on the Settlement of Investment Disputes between States and Nationals of Other States, the ICSID Convention, and the bilateral investment treaty between Sweden and Romania. On the 11th of December 2013, the tribunal issued its award, deciding that Romania had breached the bilateral investment treaty and awarding compensation of approximately £70 million plus interest. Romania unsuccessfully applied to annul the award. When Romania purported to implement the award by setting off tax debts owed by one of the claimants, the European Commission issued an injunction on the 26th of May 2014, ordering Romania to suspend any action that might lead to execution of the award until the Commission had taken a final decision on its compatibility with state aid rules. On the 1st of October 2014, the Commission formally opened a state aid investigation. On the 30th of March 2015, the Commission adopted a final decision concluding that the payment of the award by Romania constituted unlawful state aid. In 2015, the claimants commenced proceedings seeking annulment of the Commission's final decision before the General Court of the European Union. Meanwhile, in 2014, the claimants had applied for registration of the award in England and Wales under the Arbitration International Investment Disputes Act 1966, which registration was granted. In 2015, Romania applied for a stay on enforcement, and the claimants sought an order for security. In 2017, Mr. Justice Blair granted Romania's application to stay enforcement pending the General Court proceedings and refused the claimant's application for security. The claimants appealed these orders. In 2018, the Court of Appeal continued the stay, but ordered that Romania provide security. Romania appealed to this court against the order for security, and the claimants cross-appealed against the grant of a stay. That was how matters stood on the 18th of June 2019, the date set for the first day of the hearing of the appeal. However, that very morning, the General Court in Luxembourg handed down a judgment annulling the Commission's final decision on the ground that the Commission had purported to apply its powers retroactively to events predating Romania's accession to the European Union. As a result, the hearing of this appeal was adjourned to October 2019. The Commission has subsequently lodged an appeal, which is still pending, to the Court of Justice of the European Union against the decision of the General Court. At the resumed hearing of the present appeal, the issues on the claimant's cross-appeal in relation to the stay on enforcement fell into three main groups. The first group concerned the changed circumstances brought about by the decision of the General Court annulling the Commission decision. The claimant submitted that, as a result, there was no EU law duty on the courts in this jurisdiction to stay enforcement. Romania and the European Commission, intervening, submitted that the judgment of the General Court annulled only the Commission's final decision and not the injunction decision or the initiating decision. This Court considers that the judgment of the General Court leaves in existence an extant Commission investigation into state aid without a final Commission decision closing the formal investigation procedure. The effects of the initiating decision subsist, imposing a duty of sincere cooperation on the English courts. The second group of issues concerns the ICSID Convention and the 1966 Act. In its judgment, the Court emphasises that the scheme of the ICSID Convention does not permit a domestic court, before which recognition of an award is sought, to re-examine an award on its merits once its authenticity is established. The Court accepts, however, that it is arguable that there is scope for certain exceptional defences against enforcement if national law recognises them in respect of final domestic judgments, and if they do not directly overlap with those grounds of challenge which are specifically allocated to Convention organs under the ICSID Convention. Although the correct interpretation of the relevant provisions of the ICSID Convention is something which ultimately could only be authoritatively resolved by the International Court of Justice, it does not affect the outcome of the present case. This Court agrees with the majority in the Court of Appeal that courts in this jurisdiction have the power to stay execution of an ICSID award in the limited circumstances they describe. However, in the present circumstances, the grant of a stay exceeds the proper limits of that power and is not consistent with the ICSID Convention. The third group of issues concerns what is now Article 351 of the Treaty on the Functioning of the European Union. This provision is intended to ensure, in accordance with principles of public international law, that the application of the EU treaties does not affect the duty of member states to respect the rights of non-member states under a prior international agreement and to perform their obligations under such agreements. In this Court's view, the specific duties under the ICSID Convention in relation to the recognition and enforcement of awards are owed to all other contracting states, including states which are not members of the European Union. The duty of sincere cooperation does not require states in this jurisdiction to decline to decide this issue pending its resolution by the EU courts. EU case law makes it clear that questions regarding prior treaties under Article 351 are not reserved to the EU courts. The Article 351 issue here, the extent of the United Kingdom's obligations under the ICSID Convention in relation to recognition and enforcement, is not the same issue that is currently before the EU courts. The possibility that the EU courts may at some future stage consider the Article 351 issue with which this Court is concerned is contingent and remote. In these circumstances, the duty of sincere cooperation does not require the imposition of a stay of enforcement of the award. Accordingly, the Supreme Court unanimously allows the claimants cross-appeal and lifts the stay. This means that the claimants can enforce the arbitration award in this jurisdiction. In light of this, it is no longer necessary to consider Romania's appeal in relation to security, so that order is discharged.